Welcome to episode 5 and the first episode of JurisQuestHub of 2026. Happy New Year. I'm your host, Cynthia Liavule, and before we get started, please consider subscribing to JurisQuestHub. Your support will enable us to consider providing valuable content on jurisprudence and legal theory. Today's episode will be an introductory session to the first theoretical approach to jurisprudence. We will discuss this is the natural law theory. The reference material and links for today's insights will be shared in the description box. And let's get started. So today we'll be looking at the natural law through the Eichmann's case. And before we get started, I'd like us to have a quick look at the photos on the slide. We have some of the Greek philosophers, Plato, Aristotle, and later on during later times we have St. Thomas Aquinas. And then we have a photo of a person who was called Adolf Eichmann, whose case we'll be delving into as we discuss the natural law theory. So for the key ideas of natural law theory law theory can be described as being at the heart of jurisprudence because it basically raises a central question, which is whether the law is necessarily connected to morality. And this has been a discussion that has been going on for years and continues to influence philosophy as well as the application of modern day law. In my opinion, natural law theory is not a single doctrine, but rather a tradition of legal thought that is united by one central theme. And this theme is that the law is connected to morality. And from our previous episode, I referred to Brian Biggs, who is one of the authors on legal theory. He also takes this position and explains that natural law theorists tend to assert, correct, and even have some common misunderstandings in evaluating the strengths and the weaknesses of this theory insofar as modern legal systems are concerned. But the central idea remains that law is very interconnected to morality. So the central idea remains that natural law is when used to prepare or make legal rules, the rules themselves derive the authority not only from the enactment by recognized institutions, let's say parliament or whatever other authority, but from their conformity to moral principles. And these principles are universal, objective, and discoverable through human reason. So we have a photo here of human reason, and with modern technologies, of course, now we have the AI model of decision making, but ultimately we can say that all human beings have human reason. They can be able to objectively tell what is good and what is bad, and then because they have the faculty called the will, they can also be able to decide whether to choose the good or the bad. So for natural law theories, the repercussion of this is that unjust laws cannot be regarded as law, and this was famously captured by St. Thomas Aquinas in his maxim, in Latin, lex injusta non est lex. So in simple terms, it basically means that an unjust law cannot be a true law. And therefore, with this, then you have a basis for disobedience if a law is not just. So moving on to a little background about natural law. So through the episodes, we'll have a session on classical natural law, and then later on we'll have modern natural law. But to start with classical natural law, here it will just be to highlight some of the renowned authors and people who've contributed to the growth of the natural law theory. So these are classical Greek philosophers, notably from the photo we can see we have Plato, we have Aristotle, we have Cicero. And for Aristotle, for example, he viewed the law as an instrument for achieving justice and the common good. So for him, the principles of justice are natural and therefore they are valid everywhere, irrespective of our customs or enacted laws. Justice is the same everywhere. At least the notion or the principles of justice are the same everywhere. And then later on, we have St. Thomas Aquinas, who sort of systemized the thoughts that had been developed during the medieval period. So he distinguished, you could say, three spheres of law: eternal law, and for believers that's God's rational plan, and then natural law, which basically is human participation in eternal law, that is the law by God, and then human law, which are man-made rules. So for Aquinas, human laws are valid only if they reflect natural law moral requirements, and therefore what this does is that it embeds a very strong sense of morality into the concept of law. And this theory has remained foundational, because the assertion is that human laws are valid insofar as they're derived from natural law, which is in itself grounded in reason and always has to be oriented towards the common good. And therefore, an unjust law is not a law. So basically, what this can be interpreted as is that we can't deny that there's existence of unjust rules and they're usually enforced. But there's a moral judgment that unjust laws lack the moral authority that normally justifies obedience. So unjust laws may exist, yes, they may be legally valid, but they remain morally defective. And therefore, this allows the natural law theory to explain like deeply immoral legal systems, especially those in totalitarian regimes, as we saw in our previous episode, during the Nazi era, or apartheid systems or regimes. So this can exist, but they remain morally defective and therefore are illegitimate, so to say. So what are we saying? We're basically saying that for the natural law theory, there's a lot of interconnectedness between law and morality, and the legitimacy then forms the basis of the obligation either to obey or not to obey. So legal authority then depends on the moral content of the law. And like we've emphasized before, that there have been historical examples, and that means that legality of laws alone does not ensure legitimacy. So for natural law theorists, you could say that legal systems do not merely like describe social facts or stipulate how power should be exercised, but then they also like make moral claims about authority, the obligation to obey, and the legitimacy of the law. So so basically what we are saying is basically an approach that looks at what deserves to be treated as a law in a normative sense. So we're looking at the moral authority of law, not simply just the existence because a law has been enacted or it has been put in place by the respective authority, but that it has moral legitimacy. Then moving on to modern natural law. So modern natural law, here we have photos. We have John Finnis on your right and Lon Fuller on your left. Lon Fuller, we have mentioned him in our previous episodes. So despite that rich historical doctrine related to natural law, modern natural law theorists have revived it, but their premise is now more based on practical human reason and the quest for basic human goods. Yeah, so life, knowledge, social relations, and this has been asserted a lot by John Finnis. So he basically tries to ground natural law theory on practical human reason and human good, and not purely theological foundation as had been previously postulated by St. Thomas Aquinas, which is a good thing, because then it provides room for argument, it provides room for sharing of ideas and approaches, basically on using human reason. And what Finnis helps us to think about is also whether the human person can use human reason to objectively determine basic goods for all, and whether there is objective morality. And this therefore provides a very useful lens, because then we have topics like human rights, we have issues and concerns like euthanasia, we have legal issues like surrogacy, human sexuality, we have abortion, where we have a balance between individual human freedom, so to speak, and the role of the law in promoting the good of the individual and also the common good. So I think for a fact natural law really puts it in a pedestal, on a place rather, to be able to think, is there an objective good that can be universally accepted by all person? Is there objective morality? And what is the place of human reason and human will in decision making and formulation of laws? So this is the juice of today's episode, and I think this then puts natural law on the weighing scale, because then we're able to see its repercussion or its impact in the way judgments can be made by courts. So we can see that it's natural law presents a powerful attempt to anchor the law in morality and reason. So of course, these challenges, they're challenges because we live in a pluralistic society, but then it keeps us going back to the key central question that we talked about at the very beginning, that we have to keep asking ourselves, is there objective truth? Is there objective justice? And then the place of obedience and authority insofar as laws that are unjust. And this, I think, is not a problem that can be solved once and for all and at once because of the existence of human freedom. But then what I think it keeps reminding us is that the law cannot be fully understood without engaging moral questions. And this is because it's a reflection of the complexity of the human person, his social nature, and his quest through the exercise of his freedom to attain his highest good. And in this case, the Eichmann case, we're going to go through the facts, but it provided a basis for the prosecution of Eichmann. And although the case highlights many legal issues, notably the question of the legality of the universality of jurisdiction, especially with regard to, you could say, international crimes committed in a foreign country, I'm going to basically focus on the application of natural law that led to the verdict of the court and the final execution of Eichmann. What happened is that there were many issues that were discussed, notably universal jurisdiction, and some of the legal issues that arose were whether he could be tried as a foreign national for crimes that he committed abroad, and then of course the manner that he was captured, whether that could invalidate jurisdiction, and whether his obedience to his superiors could excuse his criminal responsibility. So as a sum up, the court held that his crimes were universal in nature, and his abduction did not negate jurisdiction, especially after the consent by Argentina, and he could not use obedience to the orders he had been given by his superiors as a defense for his crimes that he had committed against humanity. So from this, we can basically see what natural law is trying to say, that law is not merely a system of rules that are enacted by a sovereign authority, but it's a normative order. They are normative orders that are grounded in objective moral values. So and for the classical natural law theorists, you could say that these laws derive their authority from their consistency with a higher moral law rooted in reason and human dignity. And insofar as these laws did not have good moral foundations, because of course they involved the torture and murder of Jews, and even though they were lawful under the legal system of the Nazi, they were unjust laws, and an unjust law is therefore not a law. So the laws, insofar as they mandated racial persecution, deportation, extermination, directly contravened universal moral norms and protecting human life and dignity. And because they lacked legitimate legal authority, they could not confer moral legal justification upon those who justified them. So from the Eichmann case, that we see that the crimes committed during the Holocaust constituted violations of the foundational norms of law, and Eichmann was bound by a higher law that transcended the domestic law of the Nazi state, and his conduct was wrongful regardless of its formal legality. And then also, one of the things that it brings out is that natural law forms a good foundation for international criminal law, because then it asserts that jurisdiction over crimes against humanity and applying legal standards beyond those of a single state of a nation is recognized, and therefore there's the existence of a universal legal order that is grounded on shared moral values. And this is what we said at the beginning, the sort of universal nature of the law that natural law tries to posit, that is based on objective morality and objective principles, and therefore those need for international accountability, so to speak, in this case. And therefore Eichmann was convicted, and none of his appeals went through. So this brings us to the end of today's episode, and you're most welcome to in-depth reading of the texts that were used in this episode that are provided in the description text. And if you enjoyed this episode, don't forget to like, to subscribe, and ring the bell. You won't want to miss the next one. Happy New Year once again, and see you in the next episode.